All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Counsel, if you'd like to come forward, I will just call the docket since we have only one case today. Once you get settled, I will. We'll have you still come to the lectern and enter your appearances before we start argument, and then we'll let Mr. Smith return to the table, and then we'll start your argument. So I will call 125-003 State of Kansas versus Brian S. Stubbs.
May it please the court, Brian Stubbs appears through counsel, Casper Shire, Kansas Appellate Defender, present ready for argument. And Your Honor, could I please reserve 3 minutes for rebuttal?
3 minutes is reserved. Thank you.
May it please the court. Plaintiff Appellee State of Kansas appears by Senior District Assistant District Attorney John Simpson.
All right.
Thank you, Your Honor. Again, I am Casper Shire, appealing for Brian Stubbs, Kansas Appellate Defender Office. Charged with attempted first-degree murder, Brian Stubbs testified that he used a kitchen knife to defend himself from unlawful attack. A Douglas County jury acquitted him of all homicide charges, but returned a conviction for unlawful possession of a dangerous knife. In the district court, Brian had challenged under a constitutional vagueness theory, the dangerous knife statute, and he has maintained that facial challenge on appeal. The district court denied the challenge, and the Court of Appeals affirmed, finding first that Brian lacked standing to bring the challenge, and second, the 2008 Court of Appeals case State v. Moore controls the merits against Brian.
Let me ask a question. You started off by saying that they convicted him of criminal possession, but they convicted him under 216301 criminal use of a weapon?
Yes.
Okay, so not just possession, but criminal use, which is knowingly possessing with intent to use unlawfully against another, right?
Yes, and if you look at the text of the statute, Your Honor, I realize that I think the title of the statute is potentially a little bit misleading, because the elements the state has to prove are that he possessed it with a particular intent. So it is at its core a possession statute.
Well, okay. Sorry, please continue. I'm sorry.
No, that's fine, Your Honor. It's our position, of course, that the Court of Appeals was wrong both on its standing analysis and on the merits. Brian does have standing to challenge the very statute that he was convicted of violating, and Moore does not control the outcome of this challenge because it didn't reach the arbitrary enforcement prong of the vagueness test. And that is where the dangerous knife statute comes up short.
Doesn't the specific intent requirement of the statute effectively resolve arbitrary enforcement problem that you raise?
No, Your Honor, that's a discrete element. Whether we have, for example, possession of marijuana with the intent to distribute, or possession of whatever, is the one that we frequently see. And whether or not someone has the requisite intent is a completely different question from what is this substance in the first place? Is it marijuana or isn't it? And the answer to the intent question doesn't inform the first question at all.
Can you spin a couple hypotheticals that would demonstrate arbitrary enforcement?
Yes.
In other words, you've got two people, both of them have the requisite intent,
Right.
criminal intent. They possess two different things.
Right.
How would I'm having a hard time seeing the arbitrary enforcement.
Right. Let's say that one of them possesses a kitchen knife, like the one that we have in this case, and another one possesses a pocket knife.
And they both use them, those
And they
separate
both use-
instruments to stab somebody. Eh, Wouldn't they both get prosecuted?
Well, potentially they would both get prosecuted, but I think the threshold question here has to be which one of these knives is dangerous.
Well, they're
And I-
both dangerous if they end up being used to stab somebody.
Well, I think that's precisely the problem with Moore, is that it's dragging this definition of it more look to the aggravated battery context to inform its definition of what is a dangerous knife. And it said that a dangerous knife is any knife that can cause serious injury when it's used as a weapon. Well, that's all knives. That's all knives.
And isn't that exactly what this statute criminalizes? You cannot possess weapon, a dangerous knife, if you have the intent to use it for criminal purposes.
The legislature, by saying, hey, you cannot possess a dangerous knife, clearly intended to limit the universe of knives in some way. But the way they've done it opens up the doors to arbitrary enforcement, because they've said the group of knives that you can't possess with this particular intent is dangerous knives. And there's no principled way, the legislature provides no principled way for executive branch actors and for jurors to sort out which knives are the regular ones and which knives are dangerous, because there is no way.
Why does it matter? I think that's Justice Steagall's question. I mean, and let's take it out of the context of a knife and say it's a baseball bat. And possessing a baseball bat isn't a dangerous weapon always, but if it's used in a manner in which you club somebody to death or hit them over the head, it is.
Exactly.
And so does your arbitrary enforcement argument impact that analysis?
I think a good way to look at this. First of all, this goes back, I think, to Justice Standridge's first question, which is this is a possession statute. This is not, the mens rea is possessing this item. It is not used.
It's not used.
Yeah, I disagree. I disagree. When you look, it says possessing with the intent to use. Now, I think in Harris, that was a possession statute. Possess, it's illegal to possess. Here you have, it's illegal, it's possessing with intent to use it unlawfully against someone else. That's not a possession statute.
Respectfully, I believe it is, Your Honor, because the mens rea of the offense is not battering somebody. It's not harming somebody. It's not assaulting somebody. It is having the knife in your possession with a particular specific intent. You do not have to act on that intent. That is not required.
Do
for
you
a
think
conviction.
someone who, I'm imagining a child's play set, which has like a rubber knife in it, something that we couldn't hurt somebody. Can you imagine a scenario where someone who possessed that flimsy rubber knife with the intent to use it criminally ever being prosecuted under this statute?
No, because that's not even a knife, Your Honor. It looks like a knife. It resembles a knife, but it's not a knife. It's
Well,
not sharp.
aren't you just making the state's point then that this is within common knowledge of jurors, and jurors can determine what is a dangerous knife? It's not that difficult.
What is a knife is within, I think that's fair to say that jurors know what a knife is. But to criminalize the possession of dangerous knives suggests that the regular ones are okay. And there's just no principled way for them to make that
But
determination.
what about a picnic, plasticware or whatever?
Right,
What the little knife that you get at Kentucky Fried Chicken or whatever.
right. And two responses. One, I don't think that's even a knife under I think we use knife in a couple of different ways. One, of course, is to talk about sharp things on a handle, right? That's a knife. That's the classical definition of a knife. The second definition, and the one that I think, includes the universe of things like plastic knives, putty knives, butter knives, et cetera, is something that looks like a knife, something that resembles a knife, even though it's not sharp and it doesn't do the cutting that a knife would do.
Well, aren't you contradicting your earlier argument when you said that the legislature had to have had in mind a subset of knives when they add the modifier dangerous? But now it seems to me like you're saying anything that's not dangerous is by definition not a knife.
That is the argument, I think, if I'm understanding you right, is that all knives by definition are dangerous. That is a defining feature of a knife.
But your argument is really just that this language, that the modifier dangerous is superfluous.
Well,
But that's not a constitutional vagueness argument.
I believe it is, Your Honor, where the legislature has, the problem is that the legislature, by saying dangerous knife, they've said it's not all knives we're going after, it's just the dangerous ones. But where all knives are dangerous, that really, that doesn't, it's created the illusion of a smaller set of knives that are actually illegal, when in reality, they've given executive branch actors and jurors no way to make the determination of which knives are regular knives and which are dangerous.
But if that's the fact of the,
Before we get too far, your time is almost over. I'd really like to get to standing because I don't understand. Well, what are you relying on to say that you have standing?
I think the Court of Appeals in this case overcomplicated the standing analysis. All standing requires is injury and causation.
Right, but you're saying that you're bringing a facial challenge.
Yes.
Okay, that's for an as-applied challenge.
I'm sorry, what?
That's an as-applied challenge for standing, right? You said you're bringing a facial challenge to the statute, correct?
Correct, Your Honor.
Okay, so you necessarily aren't saying that your client was injured. I mean, that's an as-applied challenge. That's not a facial challenge.
If the statute he was convicted under is facially vague, it's a nullity. There's no grounds for a conviction there. Since there is a conviction stemming from an unconstitutional statute, the conviction is the injury and the unconstitutional statute is the but-for cause of that injury. That is standing, Your Honor.
Now, standing is that, okay, so we have law that says that to bring a facial challenge, you cannot bring a facial challenge unless, if you bring an as-applied challenge, your client's conduct fits in the statute, correct? I mean, you're not saying his conduct doesn't fit in the statute, except for the vagueness argument, once you get to that. But his conduct fits within the statute, right?
Possessed a knife, yes.
So his conduct is clearly prohibited, right?
By an unconstitutional statute, yes.
But you can't get to the unconstitutional statute. You can't challenge it as vague on its face unless you first challenge it as applied to your client. We make exceptions for standing in First Amendment cases, right?
Sure.
Okay, so we don't have a relaxed standing requirement here, right?
Well, Your Honor, I would point this court back to Harris, which was also a facial vagueness challenge, where this court essentially said, look, this has been a facial challenge since the beginning. It's been maintained on appeal, and he has standing to bring that. I don't see what separates.
No, what Harris said was, we're going to not delve too deeply into standing. Instead, we're going to go straight to facial. So really never resolved the standing issue.
Well, Your Honor, I would argue that by getting into the merits, certainly implicitly, there is a finding that Christopher Harris had standing to bring that challenge. And I guess the second thing I would say is, if we need to dive that deep into the merits to determine whether or not we have standing to begin with,
You don't need to dive in for standing. All you need, a party lacks standing to challenge a statute as unconstitutionally vague when his conduct clearly falls within the statute. In other words, the challenger must prove that the statute is vague as applied to him. Here, he had a dangerous knife.
I think the problem, Your Honor, is it's vague as applied to everybody.
Right, but you can't get into the everybody for the facial until you first prove that it was vague as applied to your client. That's the status of our law. That's the status of the Supreme Court law. This has been entrenched in our history in Kansas and in SCOTUS. I mean, this is why we have the relaxed standing for First Amendment. I'm just not understanding how you're making an exception here. And I understand there's Harris out there, but Harris went to the merits, but I don't understand, I don't really, I mean, what Harris said was that we're not going to delve into the standing requirements.
Well, Your Honor, I see I'm out of time, Chief Justice.
Certainly may answer. Thank you.
Sure. Harris, as far as I know, is still good law.
What is the holding in Harris on standing? Is there a holding on standing? Or did it just go to the merits?
My reading of Harris is that the court found standing to get to the merits because it was a facial constitutional challenge. And if you cannot do that, if you cannot stand up in district court, as Brian did, and say, this statute that I have been charged with is vague as to each and every person in the state, it's unconstitutionally vague, there's no principled way to enforce it.
So what's the difference between doing that and me, somebody who has not been charged with this under the statute? Why can't I challenge it as unconstitutionally vague? Why would I, why can't I have standing then?
Because there's no injury.
Well, your client doesn't have any injury.
The conviction, the prosecution, the pretrial incarceration, those are injuries.
Not as applied to him. You haven't shown, you haven't even made a claim. You repeated over and over in your brief. This is not an as applied challenge. I am not saying that this is vague as applied to my client. I am challenging this as applied to everybody in the universe. It's facially unconstitutional. You repeat that over and over in your brief. You've never even claimed that it's unconstitutional as to your client. Vague as applied to your client. So why couldn't I just do that then?
Odine, basic standing analysis says that you have to have some injury to redress. And a general member of the public isn't injured by just having this statute on the books in the same way that Brian, who has been arrested, bound over for trial, gone to trial, been convicted, been sentenced.
But how is it vague as to him? How is dangerous vague as to him with the knife that he used?
Because it invites arbitrary enforcement. This was a kitchen knife, very much like the kitchen knives that all of us have in our kitchens. There was nothing particularly. Why the jury made the determination that this was a dangerous knife, I'm not sure. But that's just the problem, is there's no principled way to say this kitchen knife is dangerous, but that pocket knife
Maybe
isn't.
because the person, maybe because he possessed it with the intent and did use it unlawfully against another and caused him to have to have medical attention at the site and then to be immediately transferred to a hospital and have surgery immediately. Do you think maybe that is the reason that it was dangerous? That the jury, that as applied to your client, that they understood that that knife was dangerous? How could you say that that's vague as to your client?
I think you have to look at the properties of the knife, Your Honor, and not how it's used.
But, okay, and I pulled up the statute. The title of the statute is criminal use of weapons. It's not possession. And then it says what criminal use of weapons is knowingly. This is not a possession statute. This is the use of a weapon. Possessing with the intent to use a dangerous knife. I just don't understand how, as applied to your client, and that's the threshold you have to meet in order to challenge it as to everybody. That's what you have to have standing, wouldn't you? That's what you said. You have to show the harm as to your client, right?
Your Honor, at the risk of repeating myself, I think when you've got a a conviction under an unconstitutionally vague statute, that is an injury that this court can remedy.
Okay, so just one final thing, then I could similarly have standing to challenge this statute, correct? As unconstitutionally vague under your theory.
If you could show that you had been injured some way, if you were charged under the statute and taken to jail, then certainly, yes.
Thank you.
Unless this court has other questions, I think I'll save any remaining thoughts for above.
Senior Assistant District Attorney Johnson. At the state. Unless the court would otherwise direct, I plan to focus on my arguments on what I see as being the three. And first is, does reviewing Stubbs' facial vagueness challenge require that he show that his criminal use of a weapons conviction somehow causally arises from the legislature's failure to define dangerous? Second, does Harris control the merits of Stubbs' challenge? And finally, does the legislature need to define precisely how sharp, pointed, long, or serrated a knife must be for police, prosecutors, and jurors to enforce the dangerous knife prohibition in a reasoned, non-arbitrary way? Turning to the first issue, Stubbs lacks grounds to complain dangerous knife is overly vague because the statute clearly applies to his criminalized conduct. As Justice Sandridge noted, whether as a matter of standing or as a form of judicial restraint, unconstitutional government action involving no First Amendment protections can be challenged on a facial basis only by a person directly affected, and such challenge cannot be made by invoking others' rights.
Do you think that rule is sort of related to the inverse of the test for facial challenges, that you have to demonstrate that there is no constitutional application of the statute? And if you can't demonstrate that the application that was applied to you specifically is unconstitutional, there's no way it could be facially unconstitutional. In other words, is that facial standard, the standard for facial challenges somehow related to and defining that standing rule of showing individual harm or as applied harm?
I think there is a relationship. And I think this is partly why the law is a little bit murky in this area. Because
If it is, I'm wondering if that sort of characterization of the legal test for facial challenges really applies in the vagueness context, when where the test is whether it leaves room for arbitrary enforcement, as opposed to, it's hard to articulate, could there be any constitutional application when you're looking at arbitrary enforcement? Or do you disagree with that?
I don't know that I quite understand your question. If you want to clarify that, it's fine, or I can make a few comments and maybe that would perhaps answer your question, but.
Because maybe there could be constitutional applications of the statute, but it still lends itself to arbitrary enforcement by an executive branch official. So therefore, that sort of traditional test for facial challenges, that no constitutional application doesn't seem to quite align with the test for vagueness challenges. Did that help?
Somewhat. So one thing I might say, and if this doesn't address your point, feel free to stop me, is that this notion that and one that Harris recognized, that the differences between as applied and facial challenges fade considerably in the vagueness context, especially facial vagueness context. That notion says nothing about standing. It's a distinct substantive remark, because of course a facially vague law can prohibit some conduct and be impermissibly unspecific on the whole. That does not mean the law's vagueness injured a person whose conduct was clearly prohibited. And it certainly does not mean that any person convicted under a statute may facially challenge its vagueness, regardless of whether the claimed vagueness actually injured them.
Regardless of the legal test, you still, in order to demonstrate your standing, you have to have an injury, in fact.
Yes, I think the law says that to prove, in this context, Stubbs has standing, he needs to show his conduct not clearly prescribed by the statute. Or in other words, that it's at least arguable the statute was unclear as to his conduct. And we don't have that in this case. Justice Standridge has made that point, so I won't belabor it. If this court does decide to review the issue, I think it's important to discuss why Harris does not control. And then there's two main reasons. Harris addressed a different statute, and it addressed different statutory language. The criminal possession statute addressed in Harris criminalized a felon's possession of certain specified knives without respect to their intended use, making the character of the knife possessed essentially the sole determining factor for enforcement. The enforcement of this statute requires not only that the knife have a certain character, but that it also that its possessor specifically intend to use it unlawfully against another. That difference matters. The Supreme Court has recognized that the requirement of specific intent to do a prohibited act may mitigate a law's vagueness. So even setting aside how clearly or unclearly the two statutes identify the character of the knives prohibited, the criminal use statute here leaves far less room for arbitrary enforcement.
Can I ask you a question? Okay, let's say I've got a butter knife in my hand. I don't really have any particular plans for it. Probably I'll butter my bread. Maybe I'll just hold it because I like the way it looks, whatever. That's Harris. But now I have this very same butter knife. And now I have in my mind that even though he doesn't suspect it, Justice Biles has done something that makes me very, very angry. And now I intend to use this knife with one great blow to put out his eye. But I think, wow, that's not going to look very good for any of us.
This hypothetical.
And now he's put on his glasses. But that's my intent. I am very, very angry and I intend to do this in just a couple of minutes. Can I be charged?
Well,
I haven't done it yet.
so I think there are 2 points I would make. The first is that obviously not be charged, I don't believe.
Is it dangerous now?
But I believe the relevant question is not whether it is or is not dangerous, whether law enforcers have a standard for determining that. Have that here. Dangerous is a commonly defined, judicially defined word that has a settled meaning.
So I presume you think I can certainly be charged if I carry out my threat.
Correct. But not for the mere intent and possession.
And is that clear?
Statute makes that clear.
I'm gonna have to stay out of Douglas County, I guess.
How does, help me understand that last answer. Statute doesn't require the final act, does it? At least not on its face.
No, it just requires evidence of the intent.
I
to
thought,
perform.
okay, maybe I misunderstood. I thought I just heard you say that a person could not be charged with violating the statute for the mere possession plus intent.
If that's what I said, that's not what I meant to communicate. I
Okay.
meant to communicate the possession of a knife of a dangerous character with the intent to use it unlawfully against another is all you need.
All you need, okay.
Yes.
Is there such a thing as a knife that does not have a dangerous character?
I think there is. I think the dangerous standard, again, looking to common meaning, requires assessing whether the knife is capable of gravely or greatly injuring a person. And I think that's a uniform standard law enforcers can apply.
What sort of object would fit the definition of a knife, but not quite the dangerous?
Well, I guess, again, I would go back to Justice Wilson's example of a plastic butter knife. I don't think anyone would seriously contend that using that knife against another could cause them great bodily harm or grave injury. But certainly if they were to carry out that threat, then there would be a battery. And so that's sort of where the law falls.
Why do I kind of have the feeling that I need to tell you I was kidding? I'm not really mad at Justice Biles, because I think what I heard you just say is that I could be charged just for having such a
Be charged,
terrible intent.
not for simple intent, because again, it is a knife, but it is not a dangerous knife.
Well, it certainly became dangerous. It was magically transformed from a harmless butter knife to something that I could use to put his eye out.
Settled meaning of dangerous in the law is able to cause great or grave bodily harm, not simple bodily harm. And I think that's where the distinction is. But on a somewhat related note, the common and judicially defined meaning of dangerous knife needs no added definition. I think Johnson versus United States illustrates. At issue in that case was the Armed Career Criminal Act's provision imposing an increased prison term for offenders who had previously been convicted of a violent felony, which the act defined to include specific offenses and in a residual clause, any felony that involves conduct that presents a serious potential risk of physical injury to another. Supreme Court determined in that case that language in the residual clause, but two of its features made it vague under the arbitrary enforcement prong. The first was that it required estimating a prior felony's posed risk by assessing an imagined ordinary case rather than the actual crime's facts or the statutory elements. And it also offered no standards for deciding what conduct the ordinary case of a crime involves. And then on top of that, it was entirely unclear what threshold level of risk qualified as a serious potential risk. So notably, the Supreme Court emphasized that second, the statute's use of the imprecise serious potential risk language, that alone would not have violated the void for vagueness doctrine. The court wrote, as a general matter, we do not doubt the constitutionality of laws that call for the application of a qualitative standard such as substantial risk to real world conduct. The law is full of instances where a man's fate depends on his estimating rightly some matter of degree. So in that case, because the residual clause required applying that qualitative standard to a further imprecise judge-imagined abstraction of the ordinary case, statute offered significantly less predictability than one that dealt with real-world facts.
I'm glad you brought up Johnson because I was thinking about that earlier when we were talking about standing. I want to ask you, I mean, Johnson is the case cited in Harris for the proposition that in the vagueness category, the different, as you already quoted, the differences between as applied and facial fade, and that in fact, and Johnson was a facial challenge. And it was a residual clause, and the US Supreme Court reached the merits on the facial challenge. Why doesn't that just resolve this standing question?
Well, so I think there are a few things to point out. First, it's not at all clear standing was challenged in Johnson. I believe the court itself requested briefing on the constitutionality of the law.
I would agree, and here we get into the weeds, that in the majority opinion, it doesn't make it crystal clear. But the dissent in Johnson does make it crystal clear repeatedly that this is a facial challenge. The court has struck down the residual clause as facially void for vagueness. You know, that's one of the main complaints of the dissent.
Yes, and I think to the dissent's point and why Johnson doesn't control the issue of standing here, apart from the fact it didn't directly address it. In Johnson, as in Harris, the defendant actually was injured. Johnson made that clear when the court observed, as applied to Johnson's unlawful possession of the short-barreled shotgun offense, the vagaries of the residual clause yielded no answers and only questions. So even had the issue been raised, Johnson had the capability of proving an injury, and this court made similar remarks in Harris that showed it viewed the statute as applied to him as a textbook example of arbitrarily enforced law. I see that my time's up, so unless the court has any further questions, I would just ask that this court affirm the Court of Appeals, uphold the constitutionality of the criminal use of a weapon statute, and affirm Mr. Stubbs' convictions.
I'd like to highlight the problems I see with pulling these definitions of dangerous and deadly weapon that we have in other contexts like battery and robbery, and pulling them into this possession statute. If I've got an airsoft pistol and I use it to rob a bank, is that a deadly weapon? Absolutely. Is it a dangerous weapon? Yes, because the way I'm using it, the act is robbing the bank. It's putting people in fear, and the way I use it is important. The same airsoft pistol, if I'm charged with criminal possession of a firearm, is not a firearm because it's not a firearm. No matter how I use it. How I use it doesn't change what the object is. And it is our position that this is a possession statute. And I think the jury instructions bear that out. The first element is the defendant knowingly possessed a dangerous knife with the intent to use the same unlawfully. I do not have to do anything with that knife. And I think my colleague agrees with me on that. Simply having the knife doesn't even have to be in my hand. It could be in my kitchen at home. I'm still possessing it. It's within my control. If I have the requisite intent, I've committed a crime. And I think we have to look at the qualities of the knife to decide whether it's dangerous or not how it's used. And of course, it's our position the statute gives us no principled way to do that.
Why doesn't the English language just give us a principled way to do that?
Because a dangerous knife is just circular. There's no, all knives are dangerous. I shaved this morning before I came in. I used a plastic safety razor.
We talked about this a little bit when on your
Sure.
first presentation, but it just strikes me again that the problem you see is not really a vagueness problem. In fact, you're making an argument that actually everyone knows what a dangerous knife is. Can you present two different objects which would present an ambiguity that would invite the kind of vague arbitrary enforcement that?
I think a kitchen knife is actually a great example, because I absolutely think that a different jury could have come back with a different verdict here by saying, look, this is a kitchen knife very much like the kitchen knives I've got in my kitchen. I don't consider those to be particularly dangerous knives, even though, you know, they can cut, and if they're used.
That within the ordinary province of a jury to make those kind of judgments.
The problem is that the legislature has given them no guidance to do it. All they've said is dangerous knives are not okay.
Well,
But-
typically, we say that when ordinary words are used, there's no further obligation on the legislature to provide definitions.
But here we have dangerous is intended to limit the universe of knives that you can be prosecuted for, but it doesn't. All knives are dangerous. My safety razor is, if we're using the definition for more, which is the definition the Court of Appeals used, my safety razor is dangerous if I attack somebody with it. I could cut somebody pretty good.
So
I'm
based
sure.
on your argument, if the word dangerous was not in the statute, you would concede that it's not vague.
Yes. And unless this court has other questions, we would ask this court to reverse the Court of Appeals to find that the catch-all phrase dangerous knife is unconstitutionally vague and to reverse Brian's misdemeanor conviction. Thank you for your time.
Thank you. Thank you to both counsel for your arguments. The court will take this appeal under advisement. Court is now in recess.
All right.
I take that back. Court is now adjourned.